All right, good afternoon, everyone. My name is Peter Neufeld. I'm a partner at Wagner Sidlowski, and I'm also the co-chair for this event, this whole Lunch and Learn series on will challenges, along with my colleague, Professor David Friedman. The subtopic that we're going to be speaking about today deals with the intersection of will challenges and estate litigation with family law. An article for this was prepared by Amelia Yu. She'll be one of our presenters today, and that article will be uploaded to the Zoom chat for your review. Just a housekeeping note, make sure, again, you have your microphones off or muted at all times unless you're asking questions at the end of the presentations, after which you're done your question, we ask that you mute yourself again. And please do note that this seminar is being recorded. We've got two presenters today. The first is Amelia Yu. She's the founding lawyer of Elm Law. Elm Law is a fantastic firm in the Durham region with offices in Whitby and Oshawa. It provides an invaluable legal service to that region for those dealing with estate litigation and family law litigation. Amelia is well versed in both areas, hence why we're really happy to have her here today. I personally will also be speaking as well. I've already introduced myself. My practice deals with primarily estate litigation, but as you'll see, there's often a lot of family law considerations that arise, and for that reason, estate litigators really do have to know the Family Law Act quite well. A big thank you to our sponsors. Today, we've got the B'nai B'rith, Concentra Trust, Scotia Wealth Management, Torkin Mains, as well as BMO Trusts and Estates. This event is complimentary because of them. So we thank them for that. If you've enjoyed this program, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. The link for that will be added to the Zoom chat for you to click on and donate. We have Ruth, who's the director of the Manitoba region of the B'nai B'rith Canada, here with us today. She's going to be here to talk a little bit more about the organization for a minute or so and some of the great charitable work that it is doing. So Ruth, if you're there, take it away.
Thank you very much for that introduction, Peter. So my name is Ruth Ashrafi, and I'm the regional director for B'nai B'rith in Manitoba, in Winnipeg. So it is nice to talk to people who are from elsewhere. I am to talk to you guys about one of our projects that we are doing. First of all, B'nai B'rith is a Jewish advocacy organization founded in 1875, and we are the oldest human rights organization in Canada. We do many things. We fight against anti-Semitism, and we have social engagement programs. And today I want to talk to you about children's books. So that's a little bit different from wills that you are going to speak about later. And it's also a little bit more colorful than wills generally happen to be. What we do is we have a program for children in high schools, grades 9 to 12, who can write and illustrate a children's story aimed at the ages of kindergarten to grade 5 on the themes of diversity and inclusion. So these books, the children write the story, the students write the story, they make the illustrations. This, for instance, is the book about cats, all sorts of different cats. I know it's very different from wills, the topic that you are interested in, but go with me for a moment. So this is for children in elementary school, and to show that there are many different cats, just like there are many different people. Or this is a book about a boy. He wrote it himself. He is autistic. And he says, my name is Sam, and yes, I can. So instead of focusing on all the things that he cannot do, he focuses on all the things that he can do. This program is awesome because it teaches high school students that they have a voice that reaches outside of the walls of their classroom. And also it is much more interesting for elementary school children to be taught by their peers, by students, than by adults like us who are talking to them. The message comes across in a much better way. So I was told I have 2 minutes. I'm sure that I've used them up by now. If you would like to find out more about B'nai B'rith, go to our website, www.bnaibrith.ca, or go to Diverse Minds and check out our children's books. Thank you so much for the opportunity to speak about B'nai B'rith, and good luck with your session.
Awesome. Thank you so much, Ruth. I really appreciate it. Again, we really encourage you to make a donation if you've been happy with this series, and if you're just generally interested in the organization. Okay, we're going to start off the presentation. We're going to have Amelia start off. So go ahead, take it away.
Thanks so much, Peter. You can hear me, right? Yeah. Okay, so I'm really happy to be here. Actually, I'm not saying that I almost didn't make it here, but it's always a little bit crazy for me in the mornings. It's 12 and it's already been a day, but I got a phone call from the school this morning saying that one of my kids was sick on the bus and I had to go pick him up and then come here. So, you know, I'm lucky to be here because whenever he said, well, he was sick on the bus, I go, yeah, that checks out because I have things to do. So of course that's going to happen. Okay, so as Peter was touching on, at our firm, you know, we have both the estate litigation and the family law piece. And due to our complementary practices, we do get a lot of files that intersect in both areas. So I have prepared a paper, which is in the chat right now, which goes into a lot more detail about some of the topics that I'm going to address today. So I would encourage you to take a look at that. I'm really going to be doing some very basic family law concepts because I think, or I would assume that most of the people in the audience are more well-versed in estates than they are in family law. I do see some family law practitioners in the audience. So, you know, bear with me because I'll be going over the basics. So the first thing I'd like to talk to you a little bit about is whenever you have a spouse who comes in and there are estate problems to do with that spouse, one of the first questions you should be asking them is, so is there some kind of contract here, right? So in the paper, we're talking about domestic contracts and generally what they look like and what they're for. So domestic contract is really an umbrella term that deals with kind of three different types of contracts. So we're talking about a marriage contract. Sometimes people would refer to that as a prenup or a prenuptial agreement. These are for people who are about to get married or they're already married, and it sort of sets out what happens if the couple separates or if one of them dies or both of them dies. Then you have cohabitation agreements, and those are for couples who are going to live together, and it sets out the terms by which they'll live together and also what happens when one of the parties dies. And then very common is separation agreements. Separation agreements are drafted after a party separates, and it will lay out their obligations after the separation and what they're going to do now that the relationship is over, and often also will touch on what happens when one of the parties passes away as well. So when you get that, if you ask the question, do you have a marriage contract, do you have a separation agreement, and they actually do bring you some kind of contract, I think as an estate practitioner, it's important to have some kind of clue as to what a normal, but a regular agreement would look like. So these days, most family law practitioners practice with a software called DivorceMate. So a lot of these clauses and a lot of these paragraphs that are going to show up often in the separation agreements or the marriage contracts that are generated, and it's important to know what generally they look like so you can look for ways to possibly challenge that contract if that's something that you need to do as part of your job as an estate litigator. So what you're looking for really is digging into the support provisions perhaps. Are there any provisions in there that include support? What are they? What are the support obligations? What is quantum? And then estate practitioners will likely want to look into some of the general clauses. So the general clauses will say something like, this agreement survives the death of blah, blah, and blah, blah, and inures to the benefit and binds blah, 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 heirs, executors, administrators, estate trustees, personal representatives, and assigns. And they will also go ahead and say that they will usually make a will that is in agreement with the contract. And they also usually say that they're going to let their executors know where a copy of their will is located and where a copy of the agreement that the domestic contract is. So another important thing to look at is whether or not the agreement includes schedules. such as a certificate of independent legal advice or financial disclosure. So challenging a domestic contract doesn't turn on whether or not there was independent legal advice, but oftentimes if there is no independent legal advice, that can go to other problems within the contract that you may be able to hang your hat on a challenge. In terms of setting aside, so the first thing you want to think about as a threshold issue is, do you actually have to set this agreement aside or not? You know, your client, if they are the surviving spouse, they may have claims under the Succession Law Reform Act under Part 5, and I'm sure Peter will go into that in a little more detail, but they may have that claim. And as part of that section, relief or dependence relief can be awarded even where a contract exists. So maybe you don't need to set it aside. So that's something that you would do in terms of a strategy thought. But if you ultimately would like to seek equalization, then you would have to set aside if the contract precludes equalization in the event of death. So Section 56 sub 4 of the Family Law Act basically says that it allows that you can set aside a domestic contract or a provision of that domestic contract, either if a party fails to disclose significant assets, debts, or liabilities. So going back to my comment to check if there is a schedule that includes financial disclosure at the end of that domestic contract, this goes to this particular issue here. If the parties have failed to disclose something significant in their finances, that could be a reason to set aside that contract. Then if the party did not understand the nature or consequences, again, might go back to independent legal advice. Were they getting sufficient advice at the time of the signing? That's something you need to turn your mind to. And then otherwise in accordance with the law of contract. So the law of contract, obviously, when you're setting aside any contract, that's an uphill battle. So you would have to show a number of things, but the regular ways to set aside a contract or any contract we're talking about duress, undue influence, misrepresentation, mistake, non est factum. So really quick description of those. If you're talking about duress, then, you know, did they feel compelled to sign this agreement for whatever reason? There was some kind of pressure to submit. And family law right now is really, really focusing on domestic abuse and the effects of that, both physical and mental abuse, and how that affects the party's bargaining power. So when you have an unequal bargaining, one person is being abused, the other person is the abuser, that can be a reason to say that this person did sign under duress because they felt duress. Whether or not that abuse was actually physical or it was mental, that is something that you can turn your mind to. Undue influence, I think those in estate litigation know that one quite well, so I'm not going to go much into that. Misrepresentation. No, we're talking misrepresentation can also go back to that lack of financial disclosure. The courts find it important that both parties are going into this contract with open eyes and with all the information that they need to make that decision to enter into a contractual agreement, just like any contractual agreement. Mistake, is there some kind of fundamental mistake? Has there been, non est factum is simply, do I not understand the nature or consequences of this agreement? So I think overarchingly, if you have to try to set aside the agreement, then you have to look to whether or not you have any sort of grounds to stand on. And even then, it's a difficult thing to do, but of course it can be done. We have a case now in our firm where the client has told us that she signed a marriage contract approximately 2 weeks before the wedding, and there's no schedules attached. So there's no, while the agreement itself says that they exchanged financial disclosure, there's no schedule to prove that. and it says she received independent legal advice, there's also no certificates of independent legal advice attached. So this is a situation where, since they separated before the death, we as a firm are making the decision to try to set aside that domestic contract so she can bring forward an equalization claim, because there are a number of things missing that would normally be there in the domestic contract, right? Okay, so I'm going to move on to the second topic, so I don't take up all this time, and that would be a really very basic understanding of the division of net family property and equalization. So we talked about not really needing to set aside the domestic contract unless there is a need to claim equalization and the agreement purports to not allow equalization. And what am I talking about when I'm talking about equalization? Well, that's a division of the net family property. And I think overall, I think most people understand it to be kind of like, we'll split the assets in half, but it's not, it's a little more than that. So as a state litigators, you're going to be seeking an equalization in two instances. One is upon the separation of the spouses. So if they separated before death, then that equalization payment, or what the family law would call the valuation date, is calculated on that date of separation. And on the option number two is that on the death of one of the spouses. This is providing that one of the surviving spouses makes a claim to elect under 5 sub 2 of the Family Law Act. So if they decide to elect, then they are deciding to take an equalization payment in lieu of either an intestacy or what they get under the will. So really quickly, how is it actually calculated? I said it's not half, right? So first you need to determine each of the spouse's assets as of the date of separation, or I think it's more accurate to say the date of valuation, because it could either be a date of separation or date of death. And then there are certain assets that are going to be excluded from that calculation. So you also have to determine what are the values that each spouse had, what did their property worth as of the date of marriage, and that would be excluded. And so each spouse would then subtract that value of the date of marriage assets from the date of separation assets. And then you're going to come up, well, there are other exclusions as well. I don't want to get into it, but certain personal injury awards are excluded, etc. But I don't want to get into the nitty-gritty details of what is excluded from that calculation at this time, because just for time. So basically, that value that you get once the exclusions are all done is called net family property. So this value can be 0, but it cannot be a negative. So if it is a negative, then the end result will be a 0. So the spouse with the higher NFP, or net family property, would pay the one with lower NFP. And that amount is calculated by subtracting the lower NFP from the higher one and then dividing the difference equally. So example, spouse 1 has an NFP of $1 million. Spouse 2 has an NFP of $500,000. So it's 1 million less 500,000 equals 500,000. I'm sorry, I have to do math. 500,000 divided by 2 is 250,000. So spouse 1 pays to spouse 2 250,000 to equalize their two positions, right? Hence the name. So that's a really high level explanation as to how the equalization is calculated. So some limitation dates to be aware of. One is 6 years from the date of separation. That would be the limitation date to claim an equalization from the date of separation, 6 years. You've got 2 years from the date of divorce. You have 6 months from the date of a spouse's death. So I think Peter might go into that a bit more, but there is not a limitation date, but a limit as to when you can make that equalization claim or elect to equalize. Okay, so one thing I wanted to, that was in the paper in a lot more detail, but I just wanted to point out to you is you kind of have to be a little bit careful if you're dealing with a separation that occurred before the death, because a surviving spouse who is the person to whom an equalization payment is owed, they can seek that payment from the estate. But if the person to whom the equalization payment is owed dies, and then their estate can only continue a claim that has already been established in the family law courts, but they cannot commence an application. So that part of it can get a little bit sticky. And in the paper, I cite the case, which is Bradford Estate versus Kingdon, and it goes into a little bit more detail. I'll hand it over to you, Peter. I think I've talked fast enough.
Awesome. No, that's great. And it's a really good primer on, of course, marriage contracts, but also dealing with equalization. It gives sort of an understanding of, okay, what from first instance, is equalization the proper course to go here to try and secure something more from the estate than they would otherwise be able to receive under a will or intestacy. What I want to talk about today are two sort of polar opposites. One is dependent support claims, as they're commonly referred to under the Succession Law Reform Act, and the opposite to that, which would be a predatory marriage, how to deal with some of the consequences of that from a financial perspective. Dependent support claims are not per se challenges to a will, or at least not to a will's validity. You may accept that a will is valid. The issue is whether enough was provided to certain family members that were financially relying on the deceased. And if the answer is no, and they fall within a particular definition in the Succession Law Reform Act, they may be able to bring an application for dependent support after the deceased dies. It would have to be brought 6 months after probate. And in doing so, they're able to hopefully claw a certain amount from the estate for its adequate support. And adequate support is more than just, making sure you're above the poverty line. It can also include luxuries in certain circumstances. The idea is trying to get back to the standard of living that the surviving person was at the time that the deceased was alive. But of course, there's also considerations for other beneficiaries in a will, those through intestacy or other potential dependents. And this is very similar to, well, first off, I'll say that the relief for dependent support claims enshrined in Section 58 of the Succession Law Reform Act. This is also similar to the Family Law Act in a lot of situations. You look at sections 30, 31, 32 of the Family Law Act, that all puts the onus on spouses to support spouses. It puts the onus on parents to support minors, minor children. It puts the onus on adult children to support parents, and to the extent that they're capable of doing so. And if they haven't, then a court may provide orders for support under the family law legislation. In this case, with a dependent support claim, you look at certain family members that may be entitled. It could be a spouse, it could be the parents of the deceased, it could be a child of the deceased, maybe even an adult child, it could be a brother or sister of the deceased. The second threshold here is that they have to be financially dependent on the deceased at the time of the deceased's death. And unlike the equalization that Amelia has referred to in the Family Law Act, you can be a common law spouse. The spouse definition in the Succession Law Reform Act lends its definition from Section 29 of the Family Law Act, which in that case does actually include common law spouses. So it's an important strategy for those that were never actually married, perhaps though they were in a relationship for 20 years and didn't receive adequate support from the estate. Another really big family law consideration for dependent support claims is enshrined in Section 62 of the Succession Law Reform Act. And that is saying, okay, well, you've met this threshold test for, whether you have a claim for dependent support. The next step is, how much are you going to get, right? What is the quantum that you're looking at? And not exhaustive list of factors has been put in Section 62. I'll share my screen if I can, just to show exactly what we're looking at here. All right, so this is Section 62 of the Succession Law Reform Act. And you look at, there's certainly some of the more main features that people will consider: the dependent's current assets and means that they might have in the future, the capacity to contribute to his or her own support. Those are general considerations, but you can also imagine that, well, this is really often tackling the issue of perhaps a spouse that has been out of the workforce to care for the other spouse or to support the other spouse in some way. That's what they've been used to. It would be very difficult for them to get back into the labor market, particularly when they're of an advanced age. Again, the dependent's age, physical and mental health, those are all considerations that are often targeted to spouses. But there's also very specific factors here that we look at that we can really understand that we're trying to deal with spouses in this case: the proximity and duration of the dependent's relationship, the contributions made by the dependent to the deceased's welfare. Of course, that could also include an adult child. Any agreement, I'll go down here, any agreement between the deceased and the dependent. And of course, Amelia's already talked about marriage contracts and cohabitation agreements. There's specific provisions under subparagraph R. If the dependent is a spouse, they have specific categories for that. One of them is a course of conduct by the spouse during the deceased lifetime that is so unconscionable as to constitute an obvious and gross repudiation of the relationship. I've had cases before where we've brought a dependent support claim and relied on that to argue that physical abuse is a factor that the court should consider, physical abuse to the dependent, for why they should be entitled to higher support. And then that list goes on. We also have specific lists for if the dependent is a child. The aptitude, I'm looking at subparagraph B, the child's aptitude for and reasonable prospects of obtaining an education. Of course, Ontario's legislature wants to make sure that a child can actually afford an education, and at least should not be deprived of that because their mother or father has unfairly excluded them from a will. And then as well as a child's need for stable environment and further considerations if the child is over 16 and they've withdrawn from parental control. So the factors in Section 62 of the Succession Law Reform Act, there's quite a few more in there, but they're really reflective of specific familial relationships, and whether there are certain considerations that should apply that warrant a higher amount from the estate that has otherwise been provided to them. There's also something called moral obligations. Then that's sort of enshrined, not necessarily as a separate category, but really throughout these factors we've talked about. There was a Supreme Court case that you might know, Tatterin and Tatterin Estate, that really initially set out this argument to say that deceased may have moral obligations to dependents to provide for them. And the Cummings and Cummings case, which was an Ontario Court of Appeal case, applied that to the legislation in Ontario. So you have to really look at it. Again, this idea of moral obligations, although it may be abstract, it does also lend to the fact that there's a recognition that family members who are financially dependent on a deceased, that deceased may actually have, this higher meaning, this idea of a moral obligation to them. That's what I'll talk about for dependent support claims right now. I'll say that this is a really important piece of legislation. It's something that I use quite a bit, because oftentimes you will see that there is a real unfairness in the division of an estate. That person, though, that prepared the will maybe have perfect testamentary capacity. I know a lot of people want to always think that because they were removed from a will, that the person must not have had capacity. And, quite frankly, more often than not, that's not going to be the case. But that doesn't mean that there wasn't an obligation that the deceased owed them, that they didn't provide. And for that reason, a dependent support application is really powerful. The opposite to this, which is my second topic, deals with predatory marriages. This is a very, very rare situation, but it can be quite dramatic. We're talking about a situation, you can envision this often. someone who is substantially younger, and when I say substantially, it could be many, many decades younger, decides to marry someone who is much closer to the end of their life. And the allegation will be that they didn't marry them for any real love or companionship. It was really just to gain a financial advantage and to take advantage of them and likely change their wills at the time that they died, or at the time that they married, and before, of course, they've passed away. So in this situation, the policy objectives are really a contrast to the dependent support claims. We're not dealing with a meritorious dependent claim where someone's unfairly being deprived from the estate. We're looking at the opposite. This is someone who's been unfairly benefiting from someone's inheritance. The difficulty with these is that there's no predatory marriage act, right? That doesn't exist. So you have to often base challenges on capacity. And there's two important areas of capacity that we want to look at here. One is a capacity to marry, and the other is a capacity to make a will. If you've attended these seminars throughout, which I'm sure everyone has, there's the capacity to make a will has already been discussed as the Banks and Goodfellow test. I won't put it on my screen, but essentially we're looking at, can the testator understand the nature of the act and its effects? Can the testator understand the extent of the property that they're disposing? Can they comprehend and appreciate the claims that they ought to give effect to? With a view to the latter, that no disorder of the mind shall poison their affections, perverse their sense of right, or prevent the exercise of their natural faculties, and to prevent and that no insane delusion shall influence their will in disposing of their property and bring about a disposal of it, which in the mind has been sound and would not be made. That's taken from Banks and Goodfellow here. It is a relatively high test. The contrary to that is the capacity to marry. And that's been evolving over time. There's one case, Banton, which has since evolved since then, but it talked about a well-established presumption that an individual will not have capacity to marry unless he or she is capable of understanding the nature of the relationship and the obligations and responsibilities it involves. That's much lower. That is typically a much easier test to meet. Now, there's been case law since then that talks about perhaps they also need to know the nature of their affairs. Regardless, though, I would say that the capacity to marry is much lower. And so the question that arises is, well, if, you can meet the capacity to marry, then is the approach to take that you need to challenge the capacity to make a will. And the Banton and Banton case, which I've already briefly talked about, that was a 1998 decision from the Ontario Superior Court. I encourage everyone to read it. It is a very, very, popcorn eating kind of case. This involves a man who's almost 89 years old, marries a woman who is 31 years old after he moves into a retirement home. The woman was working as a waitress at the time. He left his wife to be with her. Not surprisingly, a couple days after they married, a new will was signed. A subsequent will was prepared after that fact as well. And in those cases, instead of the estate being divided between Mr. Banton's 5 children after he died, the new will provided that his new wife was to receive everything. And he died maybe a year or two after that will, I believe a couple years after that will was prepared. And so, of course, the children brought a challenge to this. They wanted to challenge, there was an issue of capacity to marry, but there was also an issue of capacity to make a will. More importantly, think about it that, back then, and frankly, up until January of 2022, entering into a marriage would revoke a will. So you can imagine that if you can have the capacity to marry, and even if you don't have the capacity to make a new will, you may create a situation where you have revoked your prior will because you established the capacity to marry. And that's what happened in this case. Justice Cullity reviewed the matter, made a determination that, you know what, Mr. Banton had capacity to marry in this case. He was a willful victim to this. He wanted to be in this relationship despite their age. However, what Justice Cullity did find was that the will was invalid, that both there was a will in 1994 and 1995 that provided to his new wife. And he made the determination that they were both invalid. And on the basis of incapacity, they went through the evidence and determined that he just did not have capacity at the time that he prepared these wills, as well as undue influence, which, as you might know, is quite a high threshold to meet. And because of this, and because of what I've referred to already, that the marriage had revoked the will, it created an intestacy. Now, they don't specify how that was structured, but my understanding would be that the children would receive the lion's share in this case, or the estate would be divided between them, which is probably a better result than what they could have expected had the prior wills been valid, because there were some significant bequests that were made. So it was a good result for the children. But you look at the policy objectives here, really what they were what the court was doing in this case was acknowledging that, this was, perhaps not acknowledging that this was a marriage that was really just after for financial gain, although there are comments to that in the case. But really, they were able to focus their analysis on, all right, does this person have capacity to make a will? They go through it, and they look and they come to the conclusion that no, that this person was persuaded by his new wife that that his children were, out to get him, that they didn't love him anymore, and he decided that it was incumbent that he change his will to make sure that his wife gets everything. And then on that basis and other grounds, they also were able to show undue influence. So it's a dramatic situation. Now, if that were to apply today, the Succession Law Reform Act has changed. Section 16 no longer applies, and so a will is not revoked per se. So the calculus might change a little bit. You'd have to look at, well, what does the prior will say? And, in perhaps not that case, but in other cases, it might mean that a prior that there may be a different distribution than just a straight intestacy. And so the strategy changes. But in any case, it is a way to try and tackle this problem of, okay, you've got a marriage that clearly doesn't look like it was entered into for the right reasons. And although it's incredibly rare to have these situations, how is a court going to tackle this? I think that's all I'm going to talk about for predatory marriages at this point. Again, I'll open it up to questions if anyone has questions at this point. Feel free to put those in the chat. Or actually, we've got a little bit more time. Amelia, did you want to talk about the differences between family law court and the estates list?
Yeah, I'd be happy to.
Thanks very much.
We talk a little bit about the estates list, and the estates list is special to Toronto, and you have judges on the estates list who very much understand estate litigation and are able to assist in a lot of great ways. But in other jurisdictions, such as Durham region, where we have the Oshawa Court, we don't have a specialized estates list. But for most estates matters, it is preferable to be on the estates list, except I would say where you have a very complex equalization claim. So equalization, while it sounds like it is just math, when the parties are exchanging their 13.1, which is the financial statements, and determining what is included in that equalization payment and what is excluded, along with maybe claims to like pension valuations, which are split at source now, but other things, the family court is more adept at handling what comes in and what comes out of what goes in and out of your financial statement, so that it's more clear what the math works out to be at the end when you're talking about what is the quantum of your equalization payment. So I find if you are dealing with strictly a fight about what the equalization payment will be, the family court is a great place to be. Practically speaking, because we are out here, you know, and I find that we deal with a lot of clients who don't have a whole lot of money. We have a lot of files now that are actually will challenges that have been brought in family court. So the way that family court works is that when an application is brought, in order to respond, you would normally have to file a 13.1 and notice of assessment in order to get your response in. And because of that, and because of the rule that no motions are to be brought before a first case conference, you're often arguing in front of a judge at a first case conference whether or not a will challenge is proper to be heard in the family court. And in multiple instances, we have had the family court judge say, yes, I feel I can hear this will challenge in a family court. And because of our clients, you know, or maybe because of our clients' finances, where they really just can't finance multiple claims in multiple courts, and the cost of that, then sometimes it is more productive to try to keep everything to one court if there are other areas of the law or other parts of that separation that need to be dealt with through the family court. So it is a case-by-case calculation for you, but you know, we prefer to be on the estates list where we can be, especially with dependents support claims. Peter, I did notice there was a question for you in the chat.
Sure. Yeah. So a first question here is dealing with, okay, what should drafting lawyers do when faced with a situation of predatory marriage? So the client comes to your office, they meet with, they have their much younger wife and they want to do a will. Well, I mean, the first thing here is there's not much you can do if they're already married as far as challenging the capacity of a will, or sorry, challenging the capacity of a marriage. But you're going to have to go through the regular Banks and Goodfellow test, and you know, take precautions that you would with anyone else who was elderly and you had doubts about their capacity. And we've talked about this in previous seminars, but you know, really want to look at, can this person appreciate the nature of their assets? Do they understand the consequences of changes that they're making to perhaps a prior will? You're best to make sure that you are meeting with your client alone. If two wills are prepared, you know, meet with them separately. Make sure that their intentions are crystal clear on what needs to happen. If you're really, you know, concerned about someone's capacity, you can demand that they provide a capacity assessment before you prepare a will. As we've talked about again in prior seminars, the cost of you know, losing business because someone doesn't want to give you a capacity assessment when you're preparing a will, it's probably going to be a lot smaller than the cost of having to deal with you know, intervening or acting as a witness in a will challenge if it turns out that that will is challenged on the basis of validity. So take all the normal precautions, I would say, that you normally would. Okay. So the one question here is, Peter, if this case was to happen today, talking about the Banting case, a will would still be invalidated because of marriage unless the will was made in contemplation of it, correct? Well, I'll tell you that Section 16 of the Succession Law Reform Act says that a will is revoked by the marriage of the testator, except where, and I think you've made reference to this, one of them is that a declaration in the will that it is made in contemplation of marriage. Section 16 of the Succession Law Reform Act has now been removed. It's been revoked, and that's effective as of January 1st, 2022, I believe. You have Section 17(2). It says, except where a contrary intention appears by the will, where after the testator makes a will, his or her marriage is terminated by a judgment absolute of divorce or is declared a nullity. So that, and they provide a certain amount of situations where that might happen. If those are revoked by a will, it shall be construed as if the former spouse had predeceased the testator. So section 17.2 is really what you're going to be wanting to look at in this case when you're determining about, how a divorce or a marriage is impacted by a will. But section 16, which was the typical provision that revoked a will upon a marriage, has now been abolished. All right. If there's any other questions, feel free to upload those to the chat, or you can ask them here as well. We've got another one here. Is there any case law in Ontario saying that there is a moral obligation to provide for an adult child in a will who is not a dependent? It's a good question. Not to my knowledge. That doesn't mean that it's not out there. But typically, when you're talking about moral obligations to provide to an adult child, it's because you're going through the test of whether someone's entitled to dependent support. Perhaps Amelia knows of some other case law.
Generally speaking, I think the inquiry would include whether or not you were that dependent child was owed child support by you. So, for example, if they're in school at the time, but I think that you would still probably qualify as a dependent. And so that caveat that you're not a dependent and you still have a moral obligation to provide, I don't think you do, I think I agree with you, Peter, is what I'm saying.
So I have a question, Peter and Amelia. Anyone can answer. I was just wondering then, what would be the point of going through the process to draft a domestic contract when you're trying to ask the court's jurisdiction to make a support award, if at the end of the day, the surviving spouse can just ask the court to ignore the contract that you drafted?
So I'll answer that. So the language is permissive. It's basically it's subjective on the court's behalf. So the court can decide whether or not they're going to make that award in spite of the existing contract. So there is a chance that they decide that the contract holds, or that that the obligations between the parties were well understood, and that there's no reason to award support in light of the contract. So you may want to challenge the validity of that agreement in order to tighten up your claims for dependent support.
Okay, thank you.
So there's another question here. Would a dependent support claim be available to an ex-spouse receiving support payments? And if so, is there an agreement about what these payments, how would that play into it? So support payments are a consideration for when dealing with a dependent support claim. Amelia, I wonder, do you have an answer to this one?
In terms of a comment on that, so if there is a domestic contract or a separation agreement, which deals with those support payments, often family lawyers will put in clauses about insurance that are insurance proceeds that are security for those support provisions. So when we're talking about a claim under Part 5, we're talking about whether or not the estate has made adequate provision for the dependent. And it could be that the separation agreement provides for adequate provision through an insurance policy that was paid out for security for that support. But that would be my comment on that, to check that first, obviously. But I think if the payor, if that spousal support was in pay at the time of the death, then they would otherwise qualify as a dependent. And then that second piece about whether adequate provision has been provided needs to be examined. I've got another question here with regards to limitation period for dependent support claims. Does the principle of discoverability apply? So in terms of the limitation date, which is 6 months from the issuance of the certificate, there is provision there that you can extend that period. Is that right, Peter? So I don't know how long that would go for, if it was years later, whether the court would consider to extend that period. And maybe they would. So there is some leeway, but the 6 months isn't a limitation period so much as it is a time that you are to put your claim in, but the court does have jurisdiction to consider an extension of that time. But again, it's not automatically, and it's not automatically based on discoverability.
And oftentimes when you're seeking to extend the deadline to claim dependent support, at the same time, you're also doing it for equalization, right? I think it's Section 2(8) of the Family Law Act that allows for extensions of these deadlines. And you're doing that really because maybe you just got on the record and one of these deadlines are coming up, and you need to make a determination as to whether you take under the will and seek further dependent support possibly, or whether you bring a claim for equalization. And so often an extension for both of those limitation periods are sought at the same time. To the extent that we call them limitation periods. I mean, they're deadlines. I'd characterize them as deadlines, not limitation periods. All right, any further questions?
I
Oh,
see Charles
hi,
with
Charles.
his hand.
Yeah, I had a question for the people who draft these domestic contracts, and as well as the people who challenge them. I've often come across a schedule where the parties say, we acknowledge that we know everything there is to know about the other side's financial background. We know everything there is to know. So does that constitute full and frank disclosure? Have you ever been able to effectively challenge that?
So for us, best practices are to include as a schedule exactly what was exchanged, because for you to put a clause into your separation agreement, for example, or your marriage contract that says, yeah, I know exactly what's going on with the other person, if there's no proof in the actual agreement, that can be a problem, because that clause is automatically generated anyway, usually, and the schedules will basically put the nail in the coffin. So that would be best practices to include, let's say, either a net family property comparison or the 13.1s, so that we know what was exchanged.
And I would agree with Amelia and say, from just a professional management standpoint, you might have a client coming in saying, oh, I know all the assets. It doesn't matter, and you don't need to do further due diligence. Don't worry. Well, okay, but think about the repercussions. Let's say something does arise, and then all of a sudden there's a claim against you, rightly or wrongly. You got to call up Law Pro, and that's going to cause a strain to your practice that could have been avoided.
Okay.
I have a question if there's still time.
Yeah, go ahead.
So my question is that if under the SLRA application, the applicant can ask the court to waive enforcement of a domestic contract, why do applicants seek to set aside these contracts?
Amelia touched on that a little bit, but go ahead, Amelia.
As I said, it's permissory. So basically, the court can decide to make an award in spite of the contract. But again, that's up to their discretion. It certainly would strengthen your case if you were able to set aside the contract to say that the court should make an award. But the other reason is because if you're seeking equalization, in addition to a support claim, then you would need to set aside the contract. I do see one other question about how does one determine there's a predatory marriage? Age is not an only determining factor. You're correct. We actually had a case in our firm very, very recently where the two folks were similarly aged, but one of them had Alzheimer's, and he was a long-term boyfriend who she had previously stated she never wanted to marry. And then suddenly, when she had lost capacity, she decided that they were going to, they were suddenly whisked off to a city hall to have a marriage with none of her family present, etc., etc. They were both the same age, and I would characterize that as a predatory marriage. He knew exactly what he was doing when he did that, and so no, age is not a determining factor as to whether or not it's a predatory marriage.
I'll also keep in mind that it's not up to a court to make determination as to whether this marriage is predatory or not. You're going to have to take it from, different angles. I talked about that. You might have to take it from, did this person have capacity to marry or to sign a will? I would say theoretically, you could also take it from the standpoint of a dependent support claim in a way, to the extent that the elderly person did have dependents and a new will was prepared and those dependents didn't receive anything. It may be that they go ahead and they bring a claim for dependent support and are able to at least diminish the financial harm that's been caused by what we would say is a predatory marriage. All right. If anyone has any further questions, happy to hear those now. It's 1 p.m. now. But if you've got any other questions, happy to answer those. Right. Okay. Thank you all very, very much. Our next presentation, I think Maddie just posted this, is going to be on the big kahuna here. We're going to be talking about trial. So we really encourage you all to attend. That's going to be on October 11th, again at noon, again by Zoom, and again, it's free. So thank you all again for attending. We hope you appreciated it. And we look forward to seeing you on October 11th.